Subscribe to our YouTube channel and press the bell icon so that you never miss any video lesson from RAU'S IAS Study Cell. Hello and welcome to the Daily News Simplified, an analysis of the Indian newspaper from UPSC perspective. Today we will discuss the daily edition of the Indian newspaper dated 17th October 2022. And the articles that we will discuss today are displayed on your screen. So let us start the discussion. This article on page number 9 is related to inner party democracy in the Indian political system. In this line, we are aware that elections are being held for the president's post in Congress party. And that is why this debate regarding the inner party democracy has come out in open. Now, if you look at the GS paper 2 in the year 2016, a question was asked regarding the Indian political party system. And the question was that the Indian party system is passing through a phase of transition which looks to be full of contradictions and paradoxes discussed. So this question clearly tells us that a question can be asked related to the issues that are happening in the Indian political system related to the political parties which is in news. And that is why in the current context when the inner party democracy is in news, it becomes an important topic for us from the mains examination perspective. Now before starting our discussion related to the inner party democracy, let us first try and understand what exactly is meant by this term inner party democracy. Now, before understanding the meaning of intra-party democracy or inner party democracy, let us first try and understand the essence of democracy. Now, normally what we are witnessing today is procedural democracy. In this, what we are witnessing is that we are following the rules of election and everything. However, the process of election is being tweaked by money and muscle power. In such a scenario, the inner party democracy or intra-party democracy becomes very, very important. In this line, the inner party or intra-party democracy refers to establishing a set of rules within political parties which promotes a bottom-up approach to decision making. Normally, we know that in the Indian political party system, we are aware that there are various issues like criminalization of politics because inevitably the political parties want to give ticket to those candidates who can win the elections on the basis of muscle and money power. Also, we are witnessing that in political parties, the heads or the presidents of the parties are inevitably from particular dynasties. And that is why, in such a scenario where intra-party democracy is not functional properly in India, it is important and it refers to establishing a set of rules within the political parties which promotes a bottom-up approach of decision making where every member of the party is involved in choosing at least the head of the political party. Now, such a bottom-up approach to decision-making ensures an effective distribution of power amongst the party functionaries and it enables inclusivity as well as participation of diverse persons. And that is why intra-party or inner-party democracy is important to make decision-making more representative, bottom-up as well as inclusive in nature. In this line, we are witnessing that recently elections are being held in the Congress party for the post of party president. In this line, we are aware that the Congress party has been accused of dynastic politics because the power has always been held mostly by only one family. This brings us to next important question, that is, why is the inner party or intra-party democracy required in Indian political system? In this line, we are aware that the Indian political party systems face various issues and which is leading to fall in the democratic credentials of our democracy. That is, we do not have a substantive democracy where everybody is participating. Now, in this line, we are aware that the political parties in India face various issues like criminalization of politics and also dynastic politics. In this regard, let us look at why is the inner party or intra-party democracy required in the first place. Now, we are aware that political parties are regarded as representatives of the people, for the people and by the people. This is mainly because the people in turn elect the political parties to form the government at the central level, at the state level, as well as in the Panchayati Raj system also sometimes. And these political parties are the ones for which people of India vote, and these parties then form the government by getting elected. And that is why it becomes crucial that these parties should also be democratic in their functioning in the internal affairs. And that has been missing in case of India because the political system is such that in which there is lack of inner party democracy in India. Now, there are certain benefits which will accrue if there is internal or intra-party democracy in the Indian political parties. Now, the first and the foremost thing that the inner party or intra-party democracy would do is that it would decrease the trust deficit among public towards the party leaders. Now, normally we are aware that most of the educated people are disinterested towards the political parties. And this is primarily because in the way in which the political parties have been functioning and they do not have any say in the internal affairs of the political parties. And that is why the inner party or intra-party democracy, and if the elections happen in case of the political parties, it would increase the transparency and it would at least increase the visibility of transparency in the political parties. And that is definitely going to build the trust of the public towards the political parties now. Secondly, it counters the tendency of hero worship amongst the political parties. In that case, we are aware that the political parties in India are known by only certain prominent figures. If you look at the regional parties, they are all premised on the basis of important leaders of the region. And they do not have any internal democracy kind of situation. And we are aware that Dr. B.R. Ambedkar had clearly identified or had cautioned against the tendency of hero worship in the Indian democracy. And that is why, if there is internal or intra-party democracy, it is going to counter the tendency of hero worship that already exists in the Indian political system. Further, it will help in making the parties inclusive. Now, normally what happens is that representation of various marginalized groups in the party is very limited. For example, if we look at the number of women getting elected for Lok Sabha or the state legislative assemblies, it is very low as compared to the male candidates. And this is primarily because the women do not have much participation in the political parties themselves. And if there are elections that are held, if there is inner party democracy, women will also get representation amongst the political parties, which in turn would lead to more number of seats being won by the women in the parliament as well as in the state legislative assembly. And overall, it would increase the representation of women across all the assemblies in India. And that is why it is said that the inner party or intra-party democracy increases representation of the marginalized groups. Further, we are aware that the most important issue that is being faced by the political system in India is the criminalization of politics. Now, this is primarily because all the political parties are giving tickets to only those candidates who have high chances of winning the election. And in India's case, we are clearly aware that only those candidates have high chances of winning the elections who have money and the muscle power, which they have acquired through illegal means, which is the primary reason for criminalization of politics. And that is why the inner party or the intra-party democracy will check criminalization of the politics. This is because the normal people will also have some say in the functioning or the way in which the political parties are functioning. And that is why money and muscle power would be discouraged. And also it promotes freedom of speech and dissent within the political parties. Now, normally the way in which the political parties have been functioning, dissent is not encouraged much. And this we are aware of even in the functioning of the parliament as well as in the state legislative assembly, where the member of legislative assemblies as well as the member of the parliament do not have much right of dissent. And that has primarily been because of one of the laws like anti-defection law, which discourages dissent because of the whip that can be issued by the party leadership. Further, because of the tendencies of dynastic politics in some of the regional political parties as well as some of the central political parties, it discourages dissent amongst the political party members. And that is why if inner party or intra-party democracy is promoted, it will help in promoting the freedom of speech and dissent within the political parties. And we are aware that dissent and freedom of speech are the essence of democracy in this regard. And also, it works as a safety valve against factionalism and split in the parties. Now, we have recently witnessed that Shiv Sena has been split into two. And that has primarily been because of common consensus amongst the party members. And that is why if inner party democracy is there, such kind of factionalism will be discouraged in the long term. So these are some of the reasons due to which the inner party or intra-party democracy becomes important, and it will also help in improving the way in which the Indian democracy has been functioning. In this regard, if you look at the constitutional or the legal framework related to inner party democracy, the most important issue that we have is that there is no statutory backing for internal democratic regulation of political parties in India. If you look at the Representation of the People Act, under its section 29A, it provides only for the registration of political parties with the Election Commission of India. Further, Supreme Court in one of its judgment has held that the Election Commission of India cannot take punitive action against the registered political parties for violating the principles of inner party democracy. And since ECI's power to require the parties to hold regular internal elections for office bearers and candidate selection is compromised in the absence of any penal provisions. In this regard, various committees have recommended statutory backing for internal democracy for political parties. And reports from the Second Administrative Reforms Commission, the National Commission to Review the Working of the Constitution, as well as Law Commission all have recommended introducing statutes to enforce internal democracy for political parties. So in this discussion, we have seen what exactly is meant by inner party democracy. Secondly, we have seen why is internal or intra-party democracy required in the first place, and also what is the current legal framework and what are some of the suggestions that have been provided by important committees like Second Administrative Reforms Commission. Now, after going through this discussion, you can try and answer this practice question from the mains examination perspective, which reads: the first step towards substantive democracy is to establish intra-party democracy. In the light of this statement, highlight the need for intra-party democracy in India and the present legal status of intra-party democracy. With this, let's take up the next news article now. This article on page number 9 is related to the new pension scheme as well as the old pension scheme. In this line, the Government of India had introduced the national pension scheme by replacing the old pension scheme where the benefits to the employees were fixed in nature. In this line, it has become a poll plank also for some of the political parties which are returning back to old pension scheme in some of the states like Rajasthan, Chhattisgarh, etc. And that is why a debate had started regarding the case for moving back to old pension scheme. In this regard, if you look at the prelims examination of 2017, a question was asked regarding the national pension system or the NPS, which was introduced by replacing the old pension scheme. So in this discussion, we'll try to look objectively towards the national pension scheme, who can join it, what is the contribution and what are the benefits. And at the end, we will look at the comparison between the national pension scheme and the old pension scheme in this regard. Now, what exactly is this national pension scheme? So it is basically a pension cum investment scheme which aims at providing old age security to the citizens of India. If you look at a point important for us from prelims examination perspective, it is regulated by the Pension Fund Regulatory and Development Authority, that is PFRDA. The second aspect is who can join this national pension scheme. So in this line, any citizen of India, which includes both resident as well as non-resident Indians, as well as overseas citizens of India within the age group of 18 to 70 years. Earlier, the maximum age for entry was 65 years of age. In 2021, the PFRDA has increased the maximum age limit to 70 years now. Further, this national pension system is applicable to both the government sector as well as the private sector. In case of the government sector, in case of central government, it was introduced with effect from January 1, 2004, except for the armed forces. In case of state government, almost all the state governments have also adopted the NPS through their own notification. As far as the private sector is concerned or the non-government sector is concerned, it includes corporates and all the citizens of India. Any individual who is not being covered by any of the above sectors has been allowed to join the NPS from 2009 onwards. So this is how people can become a member of the national pension system, both in the government sector as well as the private sector. Now, what exactly is the contribution? So now, in case of government, the government employees make a monthly contribution at the rate of 10% of their salary, and a matching contribution is paid by the government. So in case of the central government, the matching contribution would have been 10%. However, the central government has now increased the employer's contribution rate to about 14% from 1st April 2019. And the state governments have also been asked or have been given an option to increase their contribution to 14% through their own gazette notification. Then there are different types of NPS account. First is the tier 1 NPS account and second is the tier 2 NPS account. In this line, the purpose of the tier 1 accounts is the pension account, while the tier 2 accounts are in the nature of investment accounts. In the first case, the eligibility is citizens between the age of 18 to 70 years. While under the tier 2 accounts, the NRIs and the overseas citizens of India are not eligible. Further, the tier 1 account is compulsory in nature, while tier 2 is optional, where the person needs to have tier 1 account to open the tier 2 account further. Minimum contribution in case of tier 1 account is rupees 1000, while in case of tier 2 account it is rupees 250 only. The tax benefits are also available in case of tier 1 account, while there are no tax benefits in the tier 2 account because it is in the nature of investment. Further, as far as the withdrawal from the tier 1 and tier 2 account is concerned, the tier 1 accounts are restricted as per rules and the regulations formed by the government. However, the tier 2 account has unrestricted withdrawals. So then what happens to the contribution and what are the returns like in case of the national pension scheme? So if you look at the contribution, the money that is contributed is invested in certain pension funds, which in turn invest it into different asset classes like the government securities, shares, bonds, etc. in order to generate higher returns. As far as the returns are concerned, the NPS is designed on defined contribution basis wherein the subscriber contributes to his account. However, there is no defined benefit that would be available at the time of exit from the system, and the accumulated wealth will depend upon the contribution that has been made and the income that has been generated from the investment of such wealth. Now, earlier, the benefits were fixed in nature in the old pension scheme. However, in this case, it depends on the accumulated wealth, which in turn depends upon the contribution that has been made and the income that has been generated from such investments of such wealth. Then there are three ways of withdrawals from the national pension scheme. First is on normal superannuation or retirement of an employee. At that time, at least 40% of the accumulated pension wealth of the subscriber will be utilized for the purchase of annuity, providing for monthly pension of the subscriber, and the balance will be paid as lump sum to the subscriber. That is, the 40% of the accumulated pension will be given in a nature of monthly pension to the employee, while the remaining will be provided to the employee as a balance payment or as lump sum payment to the subscriber. Then upon death, the entire accumulated pension, that is 100% of the wealth, would be paid back to the nominee or the legal heir of the subscriber, and there would not be any purchase of annuity or monthly pension. Further, there can be exit from the NPS even before the age of retirement or age of normal superannuation. Now, in that case, what will happen is that at least 80% of the accumulated pension wealth of the subscriber will have to be utilized for purchase of an annuity providing for monthly pension of the subscriber, while the balance can then be paid as lump sum to the subscriber. So you can compare what happens in case of normal retirement, what happens in case of retirement before the age of normal retirement, and what happens in case of death of the employee. This brings us to the difference between the new pension scheme and the old pension scheme. In this case, first is the nature of this scheme. In the NPS, it is on the basis of defined contribution, that is where the employees and the employers both contribute in a particular manner. However, in the old pension scheme, the benefits were clearly defined by the Government of India. Further, in case of contribution, both the government as well as employees invest in this regard. However, in the old pension scheme, it was only the government which used to contribute towards the benefit of employees. Further, as far as the benefit is concerned, there is no defined benefit as the accumulated wealth will depend upon the contribution made and the investments that are made through these contributions. However, in case of old pension scheme, the benefits were defined and pension of 50% of the last drawn salary was provided, as was the case in the previous pension schemes. As far as the pension amount is concerned, it depends upon the number of years of service. That is, longer the years of service, higher the contribution and higher the pension. However, the old pension scheme depended upon the last drawn salary, and the pension used to be equal to 50% of the last drawn salary. So this is a clear difference between old pension scheme where the benefits were defined, they were not market driven, the government was bound to provide that thing. However, in the new pension scheme, it is on the basis of contribution by both the government as well as the employee, and at the same time it also depends upon the length of the service. So these are few differences between the new pension scheme and the old pension scheme, and these were some of the points related to the national pension scheme which can be important for us from prelims examination perspective also. With this, let's take up the next news article now. This article on page number 10 is related to the Collegium system in case of appointment and transfer of the judges in case of Supreme Court. Now, Collegium system is a very important topic for us from the preliminary examination perspective in the Indian polity, and it has been covered in detail in one of the previous DNS videos. So we will be revising from that video various aspects of the Collegium system and the critical analysis of this existing Collegium system.
Now, from the perspective of UPSC examination, the Collegium system is not only important in the prelim examination, it is also important under the General Studies paper 2, in which UPSC can ask questions with respect to the structure, organization and the functioning of judiciary, and Collegium is an important part of the functioning and structure of judicial system. So today we are going to talk about the important constitutional articles with reference to the Supreme Court as well as the Collegium system. We will look into the history of Collegium system, how it has evolved, as well as what are the basic tenets. And lastly, we will try to analyze the functioning of Collegium system. Do India need such kind of system or not? Through the merits and the demerits. After the entire discussion, you will be in a position to answer this prelims related question and also able to understand how the entire Collegium functions. Before that, do remember that collegium system is common for High Court and Supreme Court together. There is no collegium system separate for the High Courts or for the lower judiciary. The lower judiciary appointments are not based on the collegium system headed by the Chief Justice of India. So let's start the discussion. These are the important articles which are given in the Indian Constitution and are associated with the appointment of the Supreme Court judges. Well, Article 124(2) says that every judge of a Supreme Court shall be appointed by the President by warrant under his hand and seal. Article 124(2)(a), which is a sub-part of the above article, says that a judge may, by writing under his hand, addressed to the President, resign his office. So, the resignation letter should go to the President directly without any executive or the judicial interference. When it comes to the Article 124(4), it talks about the removal. It says that a judge of a Supreme Court shall not be removed from his or her office except by the order of the President. So here also the role of the President is very important. But this order is not subjected to the personal will of a President. This order should be passed by both the houses of the Parliament, supported by majority of the total membership of that house, and by the majority of not less than 2/3 of the members of that house present and voting. So if you are reading about the Indian polity through M. Lakshmikant book, you must have gone through different kinds of majorities which are required to pass a particular resolution. In this case, in order to pass an order through the President, Parliament have to come together. And each house of the Parliament, it is not a matter of joint sitting, each house should pass this separately with the majority, which means 50% of the strength plus 1, along with not less than 2/3 of the members who are present and voting. So this is very important thing which you need to remember for your prelims examination. This majority then will help to pass an order, which order will go to a particular judge through the President, and that judge will be liable to leave the position. Article 124(6) talks about oath and affirmation of a particular judge in a Supreme Court. It says that a person who is appointed as a judge of the Supreme Court will take an oath and affirmation before the President or any other person who is appointed by the President. And we know that these oath and affirmations are given in the 3rd schedule of Indian Constitution. So, irrespective of how a person is appointed, resignation, removal, or even the oath, everywhere you will find the mention of a single person who is the President of India. But as we know, the executive power, the real executive power of the President lies with the Council of Ministers headed by the Prime Minister. So in this case also, will, ideas, advice, everything comes from the Council of Ministers headed by the Prime Minister. President is acting as an implementing authority in this case also. And lastly, we have Article 124(7), which puts restrictions on the practice by a particular judge after the retirement. This article says that a person who has already held an office of judge in the Supreme Court will not be allowed to plead or act in any court or even before any authority within the territory of India. Are you getting this point? See, this article has actually provided an ample space for a person to act or plead in the international level. They are restricted at the national, but they are not restricted at the international level. Now, I want this from you. Who was the person who was appointed as a judge at the international level after being a judge in the Indian Supreme Court? If you know the answer, please comment in the comment box. Now we come to the point that what is a collegium? I believe all of you must have read it previously. If not, then go through this discussion in a much detail. Well, Collegium system is one where the CJI and a forum of 4 senior most judges. Well, this can differ from country to country, and it is not important that every country should have a collegium. However, it is important for India. So this system has now 1 plus 4 judges of the Supreme Court who recommend appointment and transfer. See, both appointment and transfer are part of the collegium activity of the higher judiciary. Now, what do we have learned from this definition? The first one, that there are 5 members. The second one, all of them are from Supreme Court. The third one, that they only recommend, they do not take the final decision. The fourth one, that they are looking for appointment as well as transfer for the judges. And the fifth one, that they are looking for higher judiciary only, which means they can take decisions on High Court as well as Supreme Court. So we do not have a collegium system at the High Court level. So this is what we have learned so far. Now, how collegium system came into existence? Well, it is based on the 3 important Supreme Court judgments which were made previously, and they are known as judges cases. They are 3 in number. In first case, the Supreme Court has clearly said that opinion of the Chief Justice of India and the Chief Justice of the respective High Courts were merely consultative. It means they are not final, and the power of appointment resides solemnly and exclusively with the central government. Well, in simple terms, it means that this case has proved that Supreme Court is not the final authority to decide on the appointments and give enormous power to the central government to override the opinion given by the CGI. However, under second judge's case, Supreme Court gave a different judgment. Well, this case is famously known as Supreme Court Advocates on Record Association versus Union of India, 1993. Under this case, Supreme Court has clearly emphasized that government does not enjoy primacy or absolute discretion in the matter of appointment of Supreme Court judges. Hence, what they should do? They should look for participatory consultative process, and said that the power of the executive should be just to go for providing checks and balances and not practice in absolute terms. Well, it simply means that the absolute power which was given to the executive under the first judge's case was now denied. However, still there was a set of confusion that how this consultation should be made possible. What should be the ideal criteria? What should be the procedure to go for collegium type of system? Well, this problem came to an end under third judge's case, which is also an important precedence when it comes to the presidential reference to the Supreme Court. Well, under Article 143 of the Indian Constitution, President can refer a particular matter for the advisory jurisdiction of the Supreme Court. And because of this reference, today we are having the collegium system. So, as per this case and the judgment, Chief Justice of India shall consult 4 senior most judges of the Supreme Court. Now we come to that number of 1 plus 4. And this 1 plus 4 grouping is actually the current status of the Collegium. We know that National Judicial Appointment Commission was created in order to replace the Collegium system. However, this was struck down by the Supreme Court, saying that it goes against the independence of the judiciary and balance of power. However, under this case, Supreme Court had an opinion that all the members of the Collegium, regarding their recommendation, shall put it in the writing. It means that whatever they recommend for the appointment of a particular judge should be given in a writing form. It should not be oral. Secondly, they should follow the majority rule. Now, what does it mean? It means that if the majority of the Collegium is against the appointment of a particular person, let's say 3 out of 5 members say that a particular person is not eligible to be a judge in the Supreme Court, then that person will cease to be a member in the Supreme Court. However, we have an exemption in this. A High Court judge of outstanding merit can be appointed as a Supreme Court judge regardless of his standing in the seniority list. See, the most important issue regarding the Collegium system is what amounts to meritorious eligibility. And the second important list is how to come up with an important, non-partial and ethical seniority list. If these 2 issues are resolved, Collegium system can become more accurate and trustworthy. Now, given the evolution of the Collegium system in India, now let us also look into what are the pros and cons of the Collegium system in India. The first important merit of the Collegium system is that it ensures the independence of the judiciary, because under this system, the executive control or the executive initiative comes only at the later stage or at the last stage of the appointment. So, President is not consulted while going through the merits of a particular candidate. Prime Minister or the Council of Ministers are not at all involved while listing down the important members to be appointed to the Supreme Court. Hence, it ensures the independence of the judiciary as mentioned under Article 50. As we have discussed previously, the recommendations and the views are taken in the writing format. So a person cannot deny that he or she has recommended or not recommended to a particular person in the future. So the possibility of denial in the course of appointment is ruled out. The prevalence of the majority opinion also favors that it is based on a democratic process. If more number of collegium members are against a particular person, he or she ceases to be appointed to a judge in the Supreme Court. Reservation given by even two members or the two judges in the collegium system is also taken very seriously. It means that if two members in the collegium says that a particular person is not eligible or is less eligible than the other candidate, that person is also ceased to be a member in the Supreme Court. And lastly, it allows talented lawyers from the Bar Association to be appointed as a judge. Well, this is something which is very good. It actually removes the issue of uncle judges, where the member of the judiciary who know each other favors each other. So we have that kind of issue in the lower judiciary, but appointment of the lawyers to the Supreme Court and the High Court has reduced this issue of uncle judges to a considerable level. Now let us come into the demerits of the collegium system. The first one is the lack of transparency and accountability. As we have discussed previously, because of the ambiguity in what amounts to the seniority level and what amounts to the merit of a particular person, there lies an element of lack of transparency and accountability. Despite giving the recommendation in the written format, a particular member of a collegium is not accountable to why and how they have appointed a particular person or recommended a particular person. There is no authority in India that can question that why a particular judge was appointed as a Supreme Court judge. Secondly, we have lack of consensus among the members of the collegium. The point is, let's say there are 4 members who are saying that a particular person is eligible. However, Chief Justice of India is not finding it to be eligible. There might also be a case where one person knows the background of the eligible candidate to be in the dark format. However, the other judges, that is 3 or maybe even the Supreme Court Chief Justice, say that a person is eligible. What is the solution to this kind of problem? It is yet to be answered. There have been some allegations regarding the nepotism practice in the Supreme Court, which says that number of judges who have been appointed had one or the other linkages with the past political parties or the current political parties, which actually brings down the quality of judgment in the future. We also have politicization of the judiciary, where the judges who have been appointed by the collegium, or in fact the members of the collegium, have been given political patronage in the future. We also have absence of permanent commission. Law Commission, under its recommendation of 121st report, has proposed to set up a National Judicial Service Commission to appoint judges. In fact, National Commission for the Review of Working of the Indian Constitution in 2002 report has also highlighted the need for National Judicial Commission for the purpose of appointing members to the higher judiciary. But both these recommendations were sidelined. Judiciary earlier has also declared NJAC Act, that is National Judicial Appointment Commission Act, and its particular constitutional amendment as unconstitutional. Many political scientists have called this as an overreach by the judiciary, who were not open to go for compromising situation and balance of power. Because declaring NJAC as unconstitutional has also raised fingers on the working of the judiciary, which is supporting a mechanism where judges are appointed by the judges without any role of the executive and in fact the legislation. Now, given this discussion and the analysis of the NJAC, we also come to the conclusion with this important prelims question. So read this question carefully and answer in the comment box. Let us now move to the next article for the day.
Besides the articles that we have discussed, there are 2 other important articles in today's newspaper which have been covered previously in DNS videos very recently. For example, this article on page number 8 is related to the Nobel Prize that has been awarded for economics. And the analysis of the Nobel Prize for the economics has been done in the newspaper of 11th October 2022, that is very recently. The next important article for us is on page number 10 and it is related to Global Hunger Index. Now this has also been covered recently, that is on 15th October 2022, that is just 2 days before. So that is why you can go through both these DNS videos and revise both these important topics from these particular DNS videos.